Welcome, everyone. Good morning, and welcome to today's webinar on the topic of workplace investigations. My name is Mark Soicher. I'm Human Resource Counsel at CBIA, and I'll be hosting the webinar today. For those of you from outside of Connecticut who are not familiar with CBIA, we are the state's largest employer association, offering services to member companies in a wide range of areas, including consulting and education on human resource issues, safety and business management matters, representation in Hartford at the state capitol, lobbying public officials to promote a strong business and job growth climate in the state, and we have successfully administered a large group insurance program, essentially a private exchange, since 1995. Thanks to the generous efforts and contribution of the attorneys from North Carolina today who are presenting, we're able to offer this session today at a very affordable price, free. But it's providing great value. A bit of housekeeping for the webinar today. The format will be slide presentations on your screen with voiceover commentary from presenters. We have the capability of real-time Q&A using the text box in the lower right-hand corner of your screen. If you have a question, you can type in the question. It's through a text function. We'll try to answer the questions as they come up. If there are too many of them or it's something that's not relevant to what we're discussing at the moment, we may hold off till the end, but I'm quite confident we'll have enough time at the end to pick up any and all questions. So we do have the ability to make this a more participative session, even though we're all connected remotely, but hope that you will take advantage of that if you have questions and raise them when they arise. Have a lot of information to cover, a good-sized audience, and so we'll start momentarily. This morning's presentation is being recorded, and we will send out to attendees a link to the presentation. So if you wish to review it again later or share it with some of your colleagues, we encourage you to do so. And we also have, as you see on the opening screen there and on a closing screen, the contact information for the attorneys doing the presentation, and we urge you to follow up with them directly afterwards if you have any further questions as well. Now, as for our presenters, Attorney Barry Waters and Attorney Jen Corvo. Barry is a partner with the law firm of North Carolina and has extensive experience in a wide variety of commercial litigation matters with an emphasis on employment, non-compete, and trade secret litigation. He has defended companies in all different courts and administrative agencies against employee claims involving discrimination based on age, sex, race, disability, etc., whistleblowing, retaliation, and wrongful discharge. Barry also counsels employers on human resource policies and employment laws, including effective disciplinary and termination and separation strategies designed to avoid employment litigation. Nonetheless, he has extensive experience litigating and counseling companies in all of these matters, as well as counseling companies in breach of non-compete matters, non-solicitation confidentiality, anti-piracy agreements, and claims of breach of the duty of loyalty and misappropriation of trade secrets, and has worked extensively for many years on these matters, and is one of my go-to people when I get a question on trade secret issue and the like. And obviously, investigation is a significant part of his work in sorting through those kinds of situations. Jen Corvo is an associate with North Carolina and is a member of the firm's litigation department and works with clients on a wide range of labor and employment matters, has represented public and private employers in Massachusetts and Connecticut in various court and administrative agencies, also in working with the National Labor Relations Board with labor issues, elections, unfair labor practice charges, arbitrations, and has also represented both corporations in government and internal investigations. So both bring a great deal of experience and knowledge in this area. And I'm going to turn it over to Jen and Barry right now to go through the materials.
Well, thank you very much, Mark. Enough about us. We would like to dive right into the material. So we're going to do a little back and forth. When we do these presentations live, we like to interact with the audience. It's not conducive today for that, so Jen and I will have our back and forth. So the first question is, why are workplace investigations important? And we'll talk about what an investigation is as we go on. It may be a lengthy, sophisticated exercise, or it may be simply addressing someone's complaint. So, Jen, I'm going to pose it to you. I have multiple choice here. Why do we do investigations? A, to expose the troublesome employees. B, to support the good employees. C, to determine the truth. D, to reduce litigation. Or E, all of the above.
Well, Barry, I'm very happy we're starting this presentation off with a softball. The answer is E, all of the above. As has come to no surprise to most of you, the workplace investigations can expose the troublesome employees, but there are some other benefits. It supports the good employees, the people who are doing their job appropriately, and have also had the courage and wherewithal to raise concerns. It can be a big morale booster when people who are working at your company see that their concerns are reviewed and addressed. Another good outshoot is determining the truth, as hard as that can be. And it can also reduce litigation in the sense that it could be a good defense to litigation once it's filed. But also, if these things are addressed early on and handled thoroughly and completely, it may remove the need or, in fact, the initiative of people to file lawsuits in general.
So let's spend a little bit of time on that. We have a great group of HR professionals we see on the line with us, and hopefully you've all had experience of some sort with this. But from a litigator's standpoint, we hope that we don't see many of these scenarios, that you professionals are dealing with these situations appropriately and avoiding litigation. And it's really an HR function. You want to have a very positive workplace where the good employees are incented to work hard for you, and they feel that the people that are bringing the environment down are dealt with properly. And, of course, determining the truth is a very difficult thing, which we'll spend more time talking about. But in terms of reducing the litigation, we are going to talk to you toward the end about a few cases that have been reported within the last year. Believe it or not, there are hundreds and hundreds of reported cases involving all kinds of harassment and discrimination, where what is really on trial is the investigation itself, that the HR department did a great job or did a very poor job in conducting the investigation. So we can't overemphasize the importance of doing the investigation right, A, to avoid litigation, and B, if litigation arises, to have a good defense. Unfortunately, you all may be primary witnesses in these cases. So, moving right along, what are the keys to a proper investigation? Jen, can you help us out here?
Sure. One of the initial points is neutrality, and that essentially means is we understand that being HR folks, that we get that you know the players. You may have a background or familiarity with these people, but the burden is on you to come in from a neutral standpoint without prejudging anything when you first come in. Your job is to do the investigation and to ferret out the truth as best as possible without leaning one side or the other. Another important thing is independence. We understand that you have bosses that you work for, you have supervisors, executives, and the company itself may be very interested in the outcome of this, particularly if the person who is the center of the investigation has a lot of power in the company or actually makes the company a lot of money. But it is important that your investigatory function is independent and isn't swayed by anyone outside of the process. Another thing is rigor, and we understand that you HR folks are so busy and that this is not your primary job duty, but it is important to be as rigorous as possible during these investigations because, as Barry said, these things may be looked at through a microscope years later. So if you invest the time and what little time you have really digging into these facts and being as thorough as possible, it's going to serve you in the long run. And finally, it's promptness. Again, we understand that you all are very busy, but it's important to jump on these complaints as soon as they're filed. One, because people's memories are fresh. Two, because people are going to be accessible and you're going to be able to capture whatever documents are necessary. It also prevents people from reinventing history or making stuff up. And that may mean, depending on the size of your company, taking a really long drive or hopping on an airplane in order to get there and get there promptly to deal with the issues as they arise.
Very good, Jen. So let's go back and review these elements some more. This is the gold standard of an investigation. Given all the real-world problems that you face, it's very difficult to achieve the standard, but if you read the case law, if you read the EEOC guidance on investigations, this is what they expect from on high, those who are not doing your jobs. Neutrality. Oftentimes you get a complaint from what you might call a complainer. And the natural tendency is to say, oh, not again, and to discount the story. Well, as we all know, even a complainer might have a legitimate complaint. So please try to suspend disbelief anytime you do an investigation. Second, the independence is very, very difficult to achieve, particularly the higher up in your organization the person who is accused sits. I've had the case of the Senior Vice President of Sales and Marketing for a Fortune 500 company. Very, very difficult situation for a human resources professional to be in, and frankly, even for outside counsel to be in, when the person who's bringing in the big bucks for the company stands accused of something. So you really want to ask yourself before you start an investigation, am I capable in this particular circumstance of being neutral and being independent? If not, you should think about someone else doing the investigation. One of the things that we find very helpful for our clients is as the investigation is getting underway, we will get a phone call about, look, here's my proposed game plan. I want to run it by you. Here's who I want to interview in what order and that sort of thing. But most importantly, I don't really feel comfortable doing this one because I'm not going to be independent. I've got this senior manager breathing down my neck, or the CEO is calling me up and saying what's going on. So you can use outside counsel as a sounding board for those problems. Rigor, you will see in the cases that oftentimes investigations are faulted because they interviewed one witness but not three others, that kind of thing. So you do want to follow along all leads. And promptness. This is the hardest part of your job. I will say that we did a workshop, which is a longer exercise, which we're happy to come out and do for any of you, a couple hours long, where we would also invite managers, not just HR people, so your managers get a sense for what an investigation entails and why it's important. But we did this one for a client that had a Chicago location, and soon after, the HR manager called me and said, I've got this complaint in Chicago. By the way, I've never been to our Chicago location, and what do you think I should do? And I said, unfortunately, I think you ought to get on a plane and go to Chicago. And not only was there a benefit in doing the investigation face-to-face in Chicago, but the HR manager had a great opportunity through the day to interact with employees that she had not interacted much with. So just continue that there could be a side benefit to actually getting out there in the field. So, Jen, we get to the stage of investigation. I'm going to give you another multiple choice question. Who should do the investigation? Here we go. A, whomever is not very busy. B, the most immediate supervisor. C, trained human resources professionals. D, outside legal counsel. E, a paid consultant.
Well, clearly, Barry, the answer is A, whomever is not busy. No, the answer is folks like yourself, trained human resource professionals. You know the players, you know the company in your role and what the sensitive information you have just in your day-to-day job duties. You are the appropriate person to do the investigation. Now, as Barry had mentioned before, sometimes outside legal counsel is useful if you do have a situation where you're investigating the C-suite or you're getting a lot of pressure and that your independence can be an issue. But generally, we don't advocate having outside legal counsel doing the investigation because, one, your attorney then could be a witness, but two, as you said before, I mean, this is your company. You know the players, you know the people, and you know best. And the most immediate supervisor B, not to discount their role because they're definitely helpful in knowing the people, perhaps helping gather the documentation, but the most immediate supervisor is also helpful in the sense that they should be trained to help you in the sense of if they see warning signs of an issue, or sometimes they're the first person who hears about the complaint. So they should be trained enough to know when they hear from one of the people they manage that there's an issue to know to report that back up to you and to get HR involved.
So let's focus in on you all in your professional role. We know from our experience that human resources professionals generally don't like doing investigations. It's really thankless. There's often never a right answer. It's always making your best judgment, and the best judgment can put you in an uncomfortable position with the complaining party or the person accused, or someone high up in the organization that doesn't like the way this thing is going. However, you are, as Jen said, in the best position to do this. Not only do you know the people involved, but you have a lighter touch than, say, litigation counsel, who might come in and intimidate employees, and they're not going to be as open and honest with us, frankly, as they would be with you in most circumstances. Also, outside legal counsel should be available to you as a sounding board as you go through and to defend you if there is a claim. I have done investigations at a high level, but with the understanding that I'm not going to be the lawyer directing the company on defending the litigation if I do the investigation. I can't be the lawyer and the investigator at the same time. There may be circumstances where you would use a paid outside consultant. Again, you have to look at these issues of neutrality and independence and ask yourself whether you can do it. But I would say this: if you end up with a claim that goes to court and you're in a jury trial, I think the jury is going to be very sympathetic with you as the HR person on the scene and will forgive faults in the investigation that they won't forgive if a paid consultant is involved. So those are the considerations, but for better or for worse, generally it's going to fall on your shoulders. So let's talk about the elements of an investigation. I'll kick this one off, and Jen will chime in. Obviously, you have to interview witnesses. You want to have a game plan before you start out on the investigation. You don't want to just jump in your car, rush to the remote location, and then figure out when you get there what you're going to do. So you want to have an outline. You probably want to consult with counsel before you start the investigation. And you got to decide who to interview first. In most circumstances, that's going to be the person making the complaint. You need to get the story down. You have to be sensitive to that person's desire for confidentiality. You want to say to most people involved in the investigation that the company would appreciate confidentiality, at least while the investigation is going on, because you're engaged in the search for the truth. And if people are talking to each other about the investigation as it's going on and tipping people off who might have information developed, it's going to interfere with your investigation. Cautionary note, both the National Labor Relations Board and the EEOC says you can't tell people that you can't talk about this stuff. From the viewpoint of the National Labor Relations Board, there could be an engagement in concerted protected activity because people want to talk about how to protect themselves in these situations. And the EOC is concerned that if you go overboard on the confidentiality requirement, people will be discouraged from filing complaints to the EOC. So you want to be very careful about that. You never want to tell people they cannot talk about it, but you want to emphasize the importance of the confidentiality during the investigation. And certainly for the person making the complaint who may be very sensitive about this thing getting around. We're going to give you one case example where it did get around and the company ended up paying for that. Anti-retaliation. Every single person you talk to, you have to say there'll be no retaliation for making the complaint. Sometimes you get a complaint that you find is not valid, but you still can't retaliate against the person for making the complaint as long as the complaint was made in good faith. If you were determined that someone made up a bold-faced lie, then you would terminate that person in all likelihood. So there may be circumstances where you would, in effect, retaliate, but it's not for making the complaint, it's for telling a lie. Certainly when you talk to the person accused, you want to make sure that person knows that there shall be no retaliation. You want to make sure the immediate supervisor knows that, who may side with the person who's been accused. And you want every witness to know that their participation will not result in some kind of bad treatment. We could spend a whole lot of time on those elements. Again, if we did a workshop, we'd have a lot of interaction on those elements. Document collection. In today's world, email, text messages, voicemail messages, it's all out there. You want to involve your IT department. You want to collect the information that you can collect without interviewing witnesses. But, of course, you want to ask the person who's accused and the person making the accusation, what documentation do you have of this incident or this pattern? Now, after you've done all that, and it may involve re-interviewing the principal witnesses, you may decide that you're going to interview the person making the accusation, ask that person who can corroborate your story, go to those people first and then to the person who's been accused, or you may go to the person who's been accused second and then get the other witnesses and go back to the person who's been accused and say, well, you told me that you weren't even in the building on that day, but I have two people who say you were. So you do need to follow that down. But in the end, after you've done this thorough job, you do have to evaluate who's telling the truth. And you do have to come to a conclusion. And that's the hard part. And when you come to the conclusion, you want to do your best to remain independent and neutral. And so in the end, you may say, well, I believe her and not him, or him and not her, and that's your conclusion. And then we talk about remedies. Again, very helpful if you have outside counsel to be kicking the stuff back to counsel and saying, look, here's what I came up with. Help me decide what to do here. Chances are, whatever you decide to do, someone's going to be very dissatisfied. So now we're going to hop into a few case examples. And
Barry?
Yep.
Barry, this is Mark. Before we jump over to that, in terms of the interview process, many times someone conducting an interview, most of the time they'll be taking some notes, and it may be rather cryptic notes that ultimately later they will transpose or translate or expand upon into some more detailed statements, things like that. What's the status of the notes they're taking through the process? Is that discoverable evidence later on down the road? Can they toss out notes that are initially made and then transposed into a more extensive summary of the interview?
Very good question, Mark, and it leads to a whole host of other considerations. So when you're doing the interview, let's start there. Do you do the interview on your own? Do you have someone else in the room? Again, it depends on the size of your HR department and the credibility of the people involved. when I say the credibility, I mean the HR credibility. If you personally have a lot of credibility, but your assistant does not, you may not want the assistant there. The first thing is you want the person that you're interviewing to talk freely. You want the person to be comfortable with you. So that's number one consideration. But assuming that the extra person in the room is not going to change the dynamic, then you might have a second person in the room taking the notes. I know I haven't gotten to answering your question yet, Mark. I'm just trying to set the scene. If you are the only one in there, you will want to take notes, but I find that it's very distracting to be interviewed or to do an interview, trying to take notes and ask questions and listening to the answers. So what I suggest is what you do is you meet the person you're interviewing with good eye contact, you be as relaxed as possible, and you listen very carefully, ask a lot of open-ended questions, make the accused or the accuser or the witness talk, and make sure you hear it. And you can't hear it if you're writing. You can always go back and say, okay, well, thank you very, very much. Do you mind if I go over some of that? I would like to take a few notes. Then, Mark, you have your raw notes. And even if you do it in the manner I just suggested, where you're not writing as the person is talking the first time, you're likely to take cryptic notes. You're not going to write in full sentences. You're not going to get everything down. And the context. So that you want to be very, very careful about keeping those notes. The fact of the matter is,
we lost the sound temporarily there.
Oh, I'm sorry. Can you hear me now?
Yes, I can. Yes, I can, and hopefully everyone else can. But if you could back up about 30 seconds.
Okay, so what I'm suggesting is that you do not have to keep those raw notes. That if you have the time, you should really type them up into comprehensive full sentence notes, and then you can shred your initial notes. If you did keep those notes, however, once there's a claim threatened, you can't destroy them. You cannot destroy documents that might be relevant in litigation, but if it's your normal course to take the notes, transcribe them into full sentences, and then discard the notes, there's nothing wrong with that. The problem with the raw notes is if they're just fragments, a skilled lawyer on cross-examination can attack the notes and twist what you've written in a way that you'll think, well, I didn't mean that at all. But you don't want to be put in that position.
And one follow-up note about the interviews is never underestimate the power of silence. And this goes both ways. People feel this compulsion to fill the void of silence, and that can be an effective tool for you in trying to elicit information from the person you're interviewing, is just to give that pause and see what they volunteer. It's also a caution for you, though, because interviewing someone can be awkward, so resist the temptation to fill the silence with either your own commentary or chit-chat that's more than necessary to make the other person comfortable.
Very good. So we do want to dive into a few case examples. We hope they are enlightening and maybe not in altogether positive way. But
actually, Barry, one other thought occurred here in the investigative and interview process.
Sure.
Can you record the interview? Can the interviewee record the interview? And what are in your experience, what are the dynamics of that?
Yeah, very good. So there is no law that says you can't record the interview. There is no law that says the person you're interviewing can't record the interview. And going overboard, you might even have someone saying, I not only want to record it, but I want my lawyer present if I'm going to be interviewed. You cannot force an employee to engage in the interview with you. It's voluntary, and again, the human resources touch, not the litigator's touch. You want to make the person feel comfortable. If they refuse to be interviewed without their lawyer, then so be it. But you're never going to invite the lawyer. I don't think you ever want an employee to record the interview. I think that's a bad precedent, but there's no law for or against. You decide what your policy is. Once you start letting people record, you can't then tell someone else you can't record. I don't think it's a good idea to put people on edge by recording the interview. I don't think you're going to get as much information if it's recorded. However, there could be a circumstance where you're concerned that the person you interview is going to twist what was said way out of context, and you might say, I really feel more comfortable having the whole interview recorded. Again, these considerations boil down to the particular situation that you're in, and if you can bounce this stuff off of outside counsel or in-house counsel in a attorney-client privilege context. If you bounce these things off of a coworker, a manager, the CEO, and the investigation becomes part of the case, those conversations are not privileged. So you risk that whatever byplay you had with the CEO now makes the CEO a witness, and I can guarantee you the CEO will be unhappy about that. So do go to counsel in those situations. Jen, do you want to add something on this?
No, I agree. It's all about the soft touch of the HR function, and I think when both sides, particularly in the cell phone age, sort of whip out their recording devices, it tends to ratchet up the tension and sort of elevate things to a level that it doesn't necessarily need to be on. And I agree, even though you're going to have everything that's said is going to be captured, I don't think that actually elicits a full description because it adds a level of formality that I think puts everyone up on their guard at an already slightly awkward situation.
So going back to the whole notion that you don't just rush into these investigations and figure out what to do after you get there, you want to ask yourself ahead of time, what if the employee asks to have it recorded? Am I going to record? You don't want to be caught off guard with these kinds of situations and not know how to respond. And one thing you may do is when you interview witnesses, you may say, look, I don't want any recording device. I want you to put your cell phone on the table or, turn it off. Again, in a way that makes people comfortable, not to accuse them of something, but you want to make sure that you have really a confidential conversation that is appropriate to the investigation context. Lastly, Mark, I'm glad you're asking these questions because we're trying to do what might be a 2-hour presentation in an hour. I highly recommend that you ask the accused party and the accuser and maybe the other witnesses if they have firsthand information. Write out a statement after you've conducted the interview. And again, do it in a way that makes people comfortable. Well, thank you very much for what you've told me. I'm going to continue my investigation. I've taken some notes here. I think I understand what you're telling me, but it would be very helpful to me personally if you would be willing to write your statement. Pause. Yes. While it's fresh in your mind, if you wouldn't mind, I'll leave the room. You could do it right here. Now, we have seen what I would call brutal investigations, oftentimes by the security department, almost never by the HR department, where they say, essentially, you're locked in this room until you give me a statement, and then the person, I've had these cases, the person emerges with a statement, the security personnel reads the statement and basically says it's not good enough. Go back in there and rewrite it. I've had a case where the witness testified I had to rewrite my statement 4 times. That's not a good investigation, obviously. If people in the audience have questions, we could take a pause here before we start into the cases.
Nothing further. My only observation, Barry, after that, and thank you very much for your comments on that, is that HR people should conduct the interview as though they're being recorded, just on the chance, and therefore not say things that they don't want thrown back at them.
Absolutely. Great point, Mark. All right, we're going to talk about a case called New Great Logistics. Again, this is a reported case, and it's very, very recent. We could give you hundreds of examples. We've chosen 3.
And this one does not disappoint. New Breed Logistics is a company that was involved in supply chain logistics out of Tennessee. And they had a new warehouse, and 80% of the employees at that warehouse were temporary employees. Now, one of the facts that was interesting in this case is that the company's permanent employees were given a handbook with the company's sexual harassment policy, but the temporary employees weren't. They were merely given a couple days training, and part of that included the sexual harassment policy. Now, what makes this case so notable is that still in this day and age, there was a supervisor who was harassing some of these temporary employees, and in a pretty obvious way, using inappropriate language, that there was no mistake what the intent was, and there was also a complaint of actual physical touching. And so 3 female temporary employees in particular had complained that the supervisor had harassed them in this way. And in fact, a male coworker had come forward and complained on behalf of the women because he had witnessed this activity and rightly so thought it was inappropriate. Now, what even makes this case even more interesting is that the supervisor said to the people who complained that he was essentially untouchable, that he was the permanent employee, he was the supervisor, and that the management wasn't going to do anything to him, and he threatened to fire anyone at the company who complained. And in fact, he did bear this out. He would overlook infractions that tended to be minor in his book, such as, punching in and out late or early or not showing up for work. But as soon as a person rejected his advances, he would start to discipline them for those infractions or even terminate them. Now, the sort of linchpin to this case and what got the company in trouble was that one of the employees had made an anonymous hotline complaint. So at the outset, it's great that the company had this mechanism for employees to call in and raise concerns. However, the HR department only met with the supervisor who supposedly was committing these harassing activities and just asked him 5 questions, and that was it. And the bulk of the question was, did you harass these people? And of course the answer was absolutely not. And HR took that at face value. Now, some later people actually were identified as the people who had complained, and even though HR knew who these people were, they still didn't go to them and talk to them. And another interesting fact is while this investigation was ongoing and HR knew that there were certain individuals who had complained, this supervisor then turned around and terminated those employees during the investigation, and HR either never caught on or didn't take any concern with that type of activity.
So probably you're not going to be surprised that this was not a good outcome for the company, but you may be surprised at the level of the outcome. And I'm going to ask Jen multiple choices again, but I want to sort of frame it again this way. There were 4 plaintiffs in the case. 3 were temporary female employees who had been harassed. They were not highly paid. They were working in this warehouse. And then the 4th plaintiff was a male employee who had also participated in the complaint. Jen, let's see what you think about this. The outcome choices are A, defense verdict, B, $25,000 plaintiff's verdict, C, $100,000 plaintiff's verdict. By the way, those should be plural apostrophe. D, $250,000 plaintiff's verdict, or E, $1.5 million plaintiff's verdict. What's your choice?
Well, I'm going to play devil's advocate here and raise some things with the case. I mean, we had people, HR did, in fact, investigate. And, what did these people do? They just essentially told the supervisor to stop. It's not like they filed a charge or filed a lawsuit and were retaliated against. And these employees were, in fact, late, or they didn't punch in on time. So, you can't fault the supervisor for disciplining people for actual things that they've done wrong. So I'm going to say but I'll give them something. I mean, the activity was, not appropriate. So I'll throw them a bone and give them B, $25,000.
You're not very generous. This jury awarded $1.5 million, and that included damages for the harassment itself by the supervisor. It included damages for retaliation. And on appeal, this was a very interesting issue because, as Jen suggested, where's the retaliation? What happened here? Well, the court said the fact that they made a complaint to the supervisor and told him to stop, and he didn't stop, that was enough process to trigger a retaliation claim. You may already know retaliation claims are the hardest to defend because even if the underlying harassment is questionable, the retaliation claim can stand. They also awarded punitive damages. So here's a case where a jury got really mad, and they probably got really mad not so much with the supervisor, who was obviously an ogre, but with the HR department for not defending the employees, for not doing a thorough investigation, with not being willing to deal with the ogre supervisor.
And the court did bring that up in its decision because part of the company's way that it tried to get out of punitive damage was, hey, we did an investigation, we had this good faith effort. And the court pointed to all those things that Barry just mentioned. Sure, you investigated, but you investigated in name only. You only talked to one person, you only asked them a couple of questions, and it's a pretty hard sell to say that you did a good faith investigation when the very people complaining are being terminated and you don't even speak to the people who are complaining. So it's very interesting from the HR standpoint.
Well, and, unfortunately for this company, the EEOC took up the cause, and the EEOC rarely brings these kind of claims for the employees. It's normally a private attorney, or if it's a large class action, the EEOC will get involved. But obviously this was a case where the EEOC lawyers felt something needed to be done, so they found probable cause against the company and then took it on. If you read cases, and you probably don't, I'm just going to give you the citation to this because there is a lot of great stuff in terms of a learning in this case. So it's EEOC versus New Breed Logistics, and it's a 2015 case reported at 583 F. 3rd, 1057. That's 583 F. 3rd, 1057, 2015 case. All right, Jim, I think we have time for a couple more. What about the Kelly case?
So Kelly was a clerk at a sign shop, and she complained to her intermediate supervisor about her immediate supervisor's romantic relationship with a coworker. So, rightly so, HR started an investigation. Now, here's where we started to run into a couple of problems. The investigation took place. They showed up at Kelly's workplace unannounced. Kelly did not want to be interviewed in the workplace, so they actually interviewed her in a parked car. After Kelly provided HR with a statement, HR provided the wronged parties or the supervisor's actual girlfriend with a copy of Kelly's statement, which then ended up being circulated at the workplace. So all of her coworkers were able to read her complaint. And then eventually, after the company had decided that the supervisor had acted inappropriately, the intermediate supervisor was so ticked off that he actually sort of labeled her a troublemaker and transferred her to a worse job, changed her schedule so she had to come in earlier, reduced her lunch break from 60 minutes to 30 minutes, and then started making her take these refresher courses for activities such as payroll, which wasn't even a part of her job at all. So, some other things to keep in mind about what is and is not appropriate in a workplace investigation.
All right, then. So in this case, the plaintiff eventually just quit. She couldn't stand it anymore, and so it did involve a constructive discharge where, the company's point of view may be, and particularly the supervisor's point of view is, well, I don't know what happened to her. She just quit. Well, he found out later that there was a complaint filed, went all the way, you wonder in these situations why they can't be settled, because there's obviously some flaws here. But the numbers on settlement may have been vastly apart. So, Jen, here we go. Your choices: A, defense verdict; B, $25,000. You guessed wrong on that one last time. C, $100,000, and this is a single plaintiff case. D, $250,000 for the plaintiff, or E, $890,000. There's a million there that should be stricken through. I see now. We're sorry about that, but $890,000 plaintiff's verdict. This time, are you going to go a little bit higher in your guess?
Sure. I mean, she did get fed up enough to quit. But, hey, I mean, HR addressed her concerns. They investigated it, and they found out that her intermediate supervisor shouldn't have been having the relationship. So I'll give her $100,000.
Well, you're not very generous. So $890,000, not $890,000 million, but $890,000 is the correct answer. And the way that broke down, just so you know how these cases go, they awarded $139,000 in back pay. Now, good Lord, this was not a high-level employee. She should have been able to find another job right away. One of the defenses we always assert is failure to mitigate your damages. Why aren't you out there working? And unfortunately, we do have the experience where we think the plaintiff is just milking it, has no intention of working, and just waiting for a big score in the trial. But that mitigation defense rarely succeeds. If the jury is mad at the company and the company says she should have gotten another job, I think generally their attitude is, well, you put her in this spot, don't you complain about that. So $139,000 in back pay, $500,000 in emotional distress. I mean, just, on some objective basis, objective from a management lawyer's point of view, I guess, that's a crazy number. Why do you see that number? Because they were really mad at the harassment, but even madder at the HR department. That's the problem. Is if you don't do the investigation and the jury feels that the company let the complaining party down, then the jury is likely to react. $250,000 in punitive damages. You don't want to be there, because the numbers that go on top of that is the plaintiff as prevailing party then would claim her attorney's fees, and of course you've paid your lawyers too much money to take this case all the way to verdict and appeal. So you want to avoid these situations again. How do you avoid the situation? You do a thorough investigation. Here are the takeaways. You got to do the interviews thoroughly, follow down the leads. You got to keep it as confidential as possible. Obviously, passing the complaining party's statement around was a very, very bad fact that inflamed the jury, and you can't retaliate. This was an obvious case of retaliation, and you got to try to keep the management people out of the picture. All right, we have time for one more.
Gary, Jen, a point I often stress in harassment prevention training that I do, and I see a common element in those two cases. The accused is a supervisor. It's a potential quid pro quo situation, or a supervisor involved in the retaliation decisions. The role of or status of the supervisor is as a company agent, and so what the supervisor knows and what the supervisor does is often imputed directly to the company, because legally they're a member of the management team, however lesser capacity they may be in. So I think when HR learns or tilts towards a conclusion that he or she did the bad deed, it often implicates the company even more securely, and becomes difficult to say we're not so believing or we didn't know until much later.
Very good point, and again, it raises a whole host of other related points, Mark, and that is, look, before you get to the investigation stage, the HR role is to know what's going on. And you do have remote locations, and it's in both these cases, it's very easy to imagine in my mind these workplaces. These are sort of rough and tumble operations we've been talking about. The HR department is not on site. HR department in some large corporation is up in a glass tower like we are right now, and is not getting to the warehouse very often. So it behooves the HR department to be out there in the field, know what's going on, talk to employees on a regular basis, which I'm sure you always do. How's it going? And this is how you get some feedback. If you're open, if you really are looking for honest answers, you can ferret out problems before they become too large. And then when you do the investigation, even if the employee is valuable, the manager who's been complaining about it, you've got to go to someone and say, look, we can't tolerate this. We can't just look the other way. Again, the sooner you nip this in the bud, the better off you are. The problem is, with what's going on out there, some awful thing can be going on and you don't know anything about it, and you're blindsided, and even all the way to the verdict you might be blindsided because, look, maybe we believe this guy all the way through, and maybe he gave us legitimate reasons for the transfer. So you do, the best way to do an investigation, obviously, is to be very much in touch with your workforce. So we've got one more example. Jen, you want to take us through the next case?
Sure, and don't worry, in this example, HR did things right. So not all just to provide the bad cases. So Hudson complained to a senior level manager and her HR manager about sexual harassment involving her coworkers. And HR started the investigation that same day. They interviewed all the employee witnesses, which is essentially everyone in her department. And during the investigation, they realized that there had been a culture in her work group, including the person who complained, Ms. Hudson, that they were using vulgar language a lot. So they ended up disciplining everyone as part of the investigation. And the complainant was on the second to last step of the discipline track. So they didn't advance her to the final step, but they did put a note in her file that she should be mindful of her language, and no further harassment occurred. Fast forward a couple of months later, she falsified data logs and admitted to that, so the company terminated her. And Ms. Hudson then turned around and filed a claim for sexual harassment discrimination.
All right. Last difficult question for you. The outcome. Here are your choices. A, defense verdict. B, $25,000. C, $100,000. D, $250,000. E, $1.5 million. Or F, summary judgment for the company.
All right. Summary judgment for the company.
Hooray! So you can see that this was done right. If the investigation is done right, we can't guarantee you summary judgment, but we can certainly guarantee that you'll improve the outcomes. And the interesting thing about this investigation is, well, the reason we picked this case, not only because it was summary judgment for the good guys, but because here was someone who complained, and the company evaluated the situation fairly and felt that the complaining party was every bit as guilty of the bad behavior as the other people, and they were all told, knock it off, and completed their investigation. The termination several months later was based on a bona fide reason. And I'm sure you guys all get this question. We get it all the time. Well, we get the call 2 months later, hey, this employee who complained now has falsified data logs. Can we fire her? Well, of course you can. You know, what we always say is, of course you can. It's your company. You can do what you want. Let's be clear about that. And the next thing we say, are you going to be better off not firing this person under these circumstances and avoiding a lawsuit, or firing the person and risking a lawsuit? And 100% of the time, the answer comes back, we're better off firing this employee because she's a cancer, that she's a bad employee. The other employees are going to be distraught if she's not fired. But of course you have to evaluate, do we really have her on the falsifying? Because if you don't, you could face a retaliation claim for her complaint, and you could face a defamation claim for accusing her of falsifying data when she didn't do it. But assuming that you've done your homework on that, it doesn't matter that she complained 2 months before. Obviously, the reason this case went to court is she and her lawyer were complaining, well, you didn't really fire me for falsifying the data. Why you fired me because I made this complaint? Wrong. So do stand your ground. If you're making the right decisions with integrity, you're going to be far ahead of the game. We cannot guarantee no litigation. Obviously, the company did have to go to court and defend itself in this case. So I think that takes us almost to the end, Mark. If there are any other questions, we'd be happy to entertain them. Or, as you said, you can contact us directly anytime you like.
Well, one observation on that last case, Barry, it's the subject for another presentation, but to stress applying the same standards of rigor and quality control and effectiveness in doing an investigation on a performance issue. Because in that last case, ultimately the performance appraisal process and comparative to other employees who might be showing some performance shortcomings gets put on trial. And so transfer the same standards to that scenario.
I totally agree.
Yeah. One last question. It was referenced in one of those cases that the complaint initially came in through an anonymous hotline. What are your thoughts on those types of mechanisms for capturing complaints?
I think they're to the good. I think, as with any other type of complaint procedure, if you're going to have them, you better follow up on them. And our experience, particularly with larger companies that have these hotlines, is they are very good about following up on the complaints. It obviously makes it harder when you can't talk to the person who's making the complaint. It makes it all the more important that you go out to the locus, the place of the complaint, to talk to people. And it's a little harder doing the investigation because the complaint tends to be amorphous. You're not generally given as much detailed information. But absolutely, you want to provide as many avenues as you possibly can for employees to complain. And again, in defending a case, when the employee comes and blindsides you and says, I was harassed, well, you didn't call the hotline, you didn't come to HR, you didn't follow this procedure, you didn't follow that procedure. Those are all part of your defenses, that you would have stepped up and done the investigation and come to the right conclusion had the complaining party given you that opportunity.
Or possibly the hotline complaint had been placed through that system, but in a very superficial or general manner, and you really didn't have enough to go on with that. You did some preliminary inquiries, but without details, really couldn't latch on to anything of substance. And the subsequent lawsuit with great detail from the individual who actually submitted the hotline complaint could be defended on the basis that you didn't give us enough to go on.
Well, true. Absolutely. As long as you do some follow-up, even when it's a vague general complaint, that you can't ignore it.
And it could also be a good way of identifying hotspots. I mean, maybe you get a couple of vague complaints, but you notice it's all coming from a particular area and across all shifts, or maybe even particular one shift. So you may have with more than one complaint, and either further reason to go there and investigate.
Great point, Jen. And again, calling on our experience without naming names, we have had the situation where there is a particular location where there are multiple complaints coming from, and the HR people and the management team at a higher level says, okay, we got a problem here. Let's talk about how we approach it. It may not be one that requires an investigation into a particular complaint, but rather, what's going on in this workplace? We need to spend more time visiting that particular location. Okay.
All right. We're at the designated quitting hour, lunchtime. Great job, Barry and Jen. I think you really covered a lot concisely. Good examples. Got no further questions on the board, so I will call it to a conclusion. Again, Jen and Barry's contact information is up there on the screen. Feel free to follow up with them for any further questions you might want to pose directly on the topic we discussed today, or possibly to have them come out and visit your company to provide some more detailed input on this subject or any of the other areas they're skilled at. I'd really like to thank both of you and your firm, North Carolina, for contribution to this very good program, and we will be sending out a follow-up email to all of the registrants with a link to the recording and the PowerPoint slides as well. So that concludes today's webinar, and thank you to all attendees, and wish everyone a good holiday season. Take care.
Thank you, Mark. Thank you.